The Supreme Court chamber fell silent as Justice Amy Coney Barrett's gavel struck the wooden bench. Her voice cut through the tension like steel. "Miss Leavitt, this court finds your repeated statements about our recent decision deeply concerning. You stand perilously close to contempt." White House Press Secretary Karoline Leavitt stood motionless at the podium, facing the 9 justices who would decide her fate. At just 28 years old, Leavitt was the youngest person ever to face potential contempt charges from the nation's highest court. Barrett continued, her tone measured but severe, "You have 7 days to retract your statements and issue a formal apology, or this court will have no choice but to refer this matter for criminal prosecution." The gallery gasped. Reporters frantically typed on their phones. But instead of showing fear, Leavitt calmly opened a leather portfolio. "Justice Barrett," she replied, her voice unwavering, "I've prepared a 15-page legal analysis explaining why my statements are not only protected but legally correct." What happened next would stun the court, the media, and the nation. Before diving into this extraordinary legal showdown, make sure to subscribe to our channel and comment below with your thoughts on the boundaries between free speech and judicial respect. Justice Amy Coney Barrett, appointed to the Supreme Court in 2020, had established herself as a formidable judicial presence with her precise legal reasoning and unflinching demeanor. She commanded respect from both allies and opponents. At 52, Barrett had risen to become one of the most influential voices on the conservative-leaning court. Her background as a constitutional scholar and former law professor at Notre Dame made her particularly sensitive to public criticism that she deemed uninformed or misleading. Karoline Leavitt represented a new generation in Washington politics. Appointed White House press secretary just 6 months earlier, she had quickly become known for her direct communication style and unwavering defense of the administration's positions. Before entering the White House, few knew that Leavitt had graduated with honors from St. Anselm College with a double major in politics and communications, followed by little-publicized law studies she completed while working in previous governmental roles. The conflict had ignited 3 weeks earlier when the Supreme Court issued a controversial 5-4 ruling in Fairfield v. Department of Education, limiting federal oversight of state education policies. During a White House press briefing following the decision, Leavitt had stated, "This ruling represents a fundamental misreading of precedent and legislative intent. The majority opinion ignores 70 years of established jurisprudence and substitutes judicial preference for constitutional principle." The comments, stronger than typical White House responses to Supreme Court decisions, had triggered immediate backlash. Legal analysts debated whether Leavitt's statements crossed the line from criticism to contempt. Conservative media outlets called for consequences, while progressive voices defended her right to criticize judicial decisions. The stakes were enormous. If found in contempt, Leavitt faced not only potential imprisonment but the end of her rising career. For the court, particularly Barrett, this confrontation represented a test of judicial authority in an era of diminishing institutional respect. For the White House, it became a question of whether administrations could forcefully oppose court decisions without legal repercussions. The unprecedented summons for Leavitt to appear before the full court had created a national sensation. Constitutional scholars struggled to find historical parallels. The New York Times called it a constitutional crisis without modern precedent, while the Wall Street Journal described it as a collision between judicial authority and executive communication rights. As Leavitt stood in the chamber that morning, the weight of the moment was palpable. Her legal team had advised her to apologize and retract her statements immediately. The White House counsel had prepared a statement of contrition for her to deliver. The president himself had suggested a more conciliatory approach. But Leavitt had spent 3 sleepless nights researching Supreme Court precedents on contempt, free speech limitations, and the historical relationship between the branches of government. What she discovered had convinced her to take a different path, one that would either vindicate her position or end her career in spectacular fashion. Now, as Barrett announced the 7-day ultimatum, the confrontation had reached its critical juncture. The next moments would determine whether Leavitt would back down and apologize, as everyone expected, or whether she would challenge a Supreme Court justice on her understanding of the law, a strategy that most observers considered career suicide. Justice Barrett's expression revealed momentary surprise as Leavitt opened her portfolio instead of offering the expected apology. Several justices exchanged glances. Chief Justice Roberts leaned forward slightly, his interest visibly piqued. "Miss Leavitt," Barrett said, her voice carrying a note of warning, "this proceeding is not a debate. The court has made its position clear regarding your statements." Leavitt nodded respectfully. "I understand, Justice Barrett. However, before the court proceeds with its contemplated action, I believe it's my responsibility to address the legal basis for any potential contempt finding." Barrett's eyes narrowed. "Proceed, but be aware that your response here may factor into the court's ultimate decision." The warning was clear, but Leavitt remained composed as she referenced her prepared materials. "Thank you, Your Honor. I'd like to begin by addressing the specific legal standard for contempt of court as established in Bridges v. California. The reference to a 1941 Supreme Court decision caused Justice Sotomayor to look up with visible interest. In Bridges, Leavitt continued, this court held that criticism of judicial decisions, even harsh criticism, is protected by the First Amendment unless it presents a clear and present danger to the administration of justice. My statements, while direct, presented no such danger. Justice Alito interjected, "Miss Leavitt, you stated that this court ignored 70 years of precedent. That goes beyond criticism to questioning the court's integrity." Leavitt turned to address Alito directly. "Justice Alito, in New York Times v. Sullivan, this court established that debate on public issues should be uninhibited, robust, and wide open and may include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. The court specifically included judges within this framework." The chamber remained silent as Leavitt continued methodically addressing each element of potential contempt. Furthermore, in Craig v. Harney, this court held that judges are supposed to be men of fortitude, able to thrive in a hardy climate. The opinion explicitly protected criticism of judicial decisions, noting that what transpires in the courtroom is public property. Justice Barrett's expression remained stern but attentive. "Miss Leavitt, those cases primarily address the rights of private citizens and the press. As a government official speaking in an official capacity, your situation may be distinguishable." It was the opening Leavitt had anticipated. She turned to page 8 of her analysis. "Justice Barrett, I respectfully direct the court's attention to Garrison v. Louisiana, where this court specifically addressed critical speech by government officials. In that case, a district attorney's critical comments about judges were held to be protected speech. The court stated that speech concerning public affairs is more than self-expression, it is the essence of self-government." The tension in the chamber intensified as observers realized this was not simply a defiant gesture but a substantive legal argument. Reporters had stopped typing, transfixed by the unexpected direction of the proceedings. Justice Kagan leaned toward her microphone. "Miss Leavitt, while your knowledge of precedent is noted, there's a difference between criticizing a decision and suggesting the court deliberately misinterpreted the law. The latter implies bad faith." Leavitt nodded respectfully. "Justice Kagan, I appreciate that distinction. However, in Wood v. Georgia, this court protected a sheriff's statements that directly accused judges of bias and political motivation, statements far more pointed than my own. The court held that the role that elected officials play in our society makes it all the more imperative that they be allowed freely to express themselves on matters of current public importance." Barrett's expression had subtly shifted from stern disapproval to reluctant engagement with Leavitt's legal reasoning. "Miss Leavitt, you've cited several cases, but none of them specifically addresses statements made by White House officials about Supreme Court decisions." "That's correct, Justice Barrett," Leavitt acknowledged, "but I would argue that the absence of specific precedent restricting such speech should favor protection rather than limitation. As this court noted in Texas v. Johnson, we have a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open." The dynamic in the chamber had transformed. What began as a reprimand had evolved into a substantive legal discussion. Leavitt continued, citing relevant cases, explaining their application to her situation with remarkable precision. Justice Thomas, who rarely spoke during proceedings, broke his silence. Miss Leavitt, while your legal analysis is thorough, there remains the question of respect for institutions. Your statements could undermine public confidence in the judiciary. Leavitt turned to address Thomas directly. Justice Thomas, I deeply respect your concern. However, in Landmark Communications v. Virginia, this court specifically addressed that issue, stating that injury to official reputation is an insufficient reason for repressing speech that would otherwise be free. The opinion further noted that the law gives no protection to the judge who would hide behind the cloak of office to escape public criticism. The quote hung in the air, its directness causing several justices to shift in their seats. The confrontation had escalated beyond anyone's expectations. Rather than a penitent press secretary accepting the court's authority, Leavitt had transformed the proceeding into a sophisticated constitutional debate, and she showed no signs of backing down. Justice Barrett, visibly reassessing her approach, leaned forward. Miss Leavitt, are you suggesting that there are no limits to how administration officials can characterize court decisions? Not at all, Justice Barrett, Leavitt replied. I recognize that limits exist. Direct incitement to disregard court orders would clearly cross the line established in Bridges, but criticism of legal reasoning, even strong criticism, falls squarely within protected speech under this court's own precedents. As Leavitt continued her methodical legal analysis, the atmosphere in the chamber had transformed completely. What began as a disciplinary proceeding had become an unexpected showcase of constitutional interpretation, with the youngest person in the room demonstrating a command of precedent that had clearly caught the justices by surprise. The Supreme Court chamber remained unnaturally quiet as Leavitt turned to the next page of her analysis. Her voice, which had maintained its steady confidence throughout, took on an even more assured tone. If I may, I'd like to address the historical context that further supports the constitutional protection of my statements. Justice Barrett, who had planned to issue a simple ultimatum rather than engage in constitutional debate, found herself nodding permission. The dynamic had shifted dramatically, with several justices now leaning forward with evident interest. Throughout our nation's history, Leavitt continued, tensions between the executive branch and this court have resulted in far more pointed criticisms than mine without contempt proceedings. President Jefferson called Marshall's opinion in Marbury v. Madison, twistifications. President Jackson reportedly said of Marshall, John Marshall has made his decision, now let him enforce it. President Lincoln directly challenged the legitimacy of Dred Scott v. Sanford in his inaugural address. Leavitt paused, allowing the historical context to register with the justices and observers. She then moved to more recent examples. In 2010, President Obama criticized the court's decision in Citizens United during his State of the Union address with 6 justices present. In 2017, President Trump described a judge who ruled against his administration as a so-called judge. Neither faced contempt proceedings. Justice Sotomayor interjected, those were statements by presidents, Miss Leavitt. Your position is different. Respectfully, Justice Sotomayor, Leavitt responded without hesitation, the legal standard for contempt doesn't create a separate category for presidential speech versus other executive officials. And historically, press secretaries have frequently criticized court decisions. Ron Ziegler under Nixon, James Brady under Reagan, D.D. Myers under Clinton, and Kayleigh McEnany under Trump all issued statements critical of specific Supreme Court rulings. Leavitt then moved to what would become the most powerful portion of her presentation, a direct analysis of her actual statements compared to the legal standard for contempt. If I may draw the court's attention to the precise language I used, she said, producing a transcript of her press briefing, I stated that the ruling represents a fundamental misreading of precedent and legislative intent. This is a legal assessment, not a personal attack. I said the majority opinion ignores 70 years of established jurisprudence. This is a claim about legal methodology, not judicial integrity. She looked directly at Justice Barrett. Under Bridges, contempt requires a clear and present danger to the administration of justice. My statements present no such danger. They question legal reasoning, not judicial legitimacy. Barrett, who had entered the chamber confident in her position, now found herself in an unexpected situation. The press secretary she had summoned for reprimand was presenting a sophisticated constitutional defense that directly cited the court's own precedents. "Miss Leavitt," Barrett said, "while your knowledge of precedent is impressive, there remains the issue of your position as White House press secretary. Your words carry the implied authority of the executive branch." It was precisely the opening Leavitt had anticipated. She turned to the final section of her analysis. "Justice Barrett, that's an important distinction that I'd like to address directly. In Garcetti v. Ceballos, this court held that when public employees speak pursuant to their official duties, their speech may receive less First Amendment protection. However, that case specifically distinguished between internal workplace speech and public commentary on matters of public concern. Leavitt's command of the case law was remarkable, particularly as she cited specific page numbers and direct quotes from the opinions. Several clerks could be seen frantically checking her references, only to confirm their accuracy. More importantly, she continued, in Lane v. Franks, this court clarified that speech by public employees on matters of public concern deserves robust protection. A Supreme Court decision affecting national education policy is unquestionably a matter of public concern. My role as press secretary inherently involves communicating the administration's positions on such matters." The gallery remained spellbound as Leavitt methodically constructed her defense. What had begun as an attempt to discipline a presumed novice had transformed into a masterclass in First Amendment jurisprudence. Justice Barrett, recognizing the unexpected turn the proceeding had taken, attempted to redirect. "Miss Leavitt, this court has the authority to defend its institutional integrity. Your statements, regardless of their technical legal status, showed disrespect for this institution." Leavitt nodded respectfully before delivering her most powerful point. "Justice Barrett, I have the deepest respect for this court as an institution. It is precisely because of that respect that I believe we must engage in robust debate about its decisions." She paused, then quoted directly from Barrett's own judicial writings. "As you yourself wrote in your 2019 article in the Notre Dame Law Review, respectful disagreement is not disrespect. Indeed, the ability to criticize judicial reasoning is essential to the health of our constitutional democracy." The chamber fell completely silent. Barrett's own words, quoted verbatim and in context, had effectively undermined the basis for the contempt proceeding. Several justices glanced at Barrett, waiting for her response. After a moment that seemed to stretch eternally, Justice Barrett spoke. "Miss Leavitt, I appreciate the thoroughness of your presentation. The court will need to consider the points you've raised." She glanced at Chief Justice Roberts, who nodded almost imperceptibly before addressing Leavitt. "This court will take your arguments under advisement," Roberts said. "We'll issue our determination within 48 hours. This proceeding is adjourned." As the justices rose to exit, the gallery erupted in whispered conversations. Legal observers who had come expecting to witness a simple disciplinary proceeding had instead seen something extraordinary. A young press secretary had just delivered a constitutional law lecture to the Supreme Court, using its own precedents to defend her right to criticize it. The triumph was evident not in shouting or celebration but in the simple fact that Leavitt had transformed what was meant to be her reprimand into a serious constitutional deliberation. As she gathered her materials, preparing to face the media storm outside, both friends and critics recognized they had witnessed something remarkable, the emergence of a legal mind that had just stood toe-to-toe with the nation's highest court. The moment Karoline Leavitt exited the Supreme Court building, she was engulfed by a sea of reporters. Camera flashes illuminated her path as journalists shouted questions from every direction. Rather than offering impromptu comments, she simply stated, "I've presented my position to the court. Out of respect for their deliberative process, I'll reserve further comment until they've issued their determination." This measured response, contrasting sharply with the media circus surrounding her, only amplified the impact of what had transpired inside. Within minutes, legal experts across the country began dissecting the extraordinary confrontation. At Georgetown Law Center, Professor Lawrence Tribe was hosting an impromptu discussion with stunned constitutional law students. "What we witnessed today was unprecedented," he told them. A press secretary transformed a contempt proceeding into a substantive First Amendment seminar, using the court's own precedents with remarkable precision. CNN's legal analyst Jeffrey Toobin appeared visibly energized on air. "I've covered the Supreme Court for decades, and I've never seen anything like this." Leavitt didn't just defend herself, she essentially delivered a guest lecture on First Amendment jurisprudence to the justices themselves. Conservative legal commentators were similarly impressed, though more measured. Former federal judge Michael Luttig noted, "While I may disagree with Leavitt's characterization of the court's decision, her legal defense today was extraordinarily well crafted. She's raised legitimate constitutional questions that the court will need to address thoughtfully." As legal analyses flooded cable news and social media, another narrative emerged, the biographical revelation about Leavitt that had escaped public notice until now. Her law studies, completed quietly while working in government, had never been highlighted in her White House biography or public profiles. The Washington Post published a profile within hours, behind the press secretary podium, Karoline Leavitt's unknown legal background. The piece detailed how Leavitt had completed her law studies through an evening program while working on Capitol Hill, maintaining a remarkable 3.9 GPA while juggling a demanding political career. A former professor, speaking anonymously, described her as one of the most gifted constitutional law students I've encountered, someone who could recite case law from memory and apply it with unusual creativity. Inside the White House, the mood shifted from tense concern to cautious optimism. Officials who had advised Leavitt to simply apologize now gathered in the Chief of Staff's office, watching legal experts praise her performance across networks. "She never told us she was going to do this," one senior advisor was overheard saying. "We had the apology statement ready to go. Nobody knew she'd spent the weekend building a constitutional defense." The president, who had initially worried about the political fallout of a contempt citation, called Leavitt personally. According to sources familiar with the conversation, he simply said, "You made history today. Whatever happens next, I'm proud to have you representing this administration." Meanwhile, inside the Supreme Court chambers, an extraordinary conference was taking place. The 9 justices, who rarely convened emergency discussions, gathered to address the unexpected constitutional challenge Leavitt had presented. According to sources close to the court who later spoke to The New Yorker, Justice Barrett opened the discussion by acknowledging the complexity of the situation. "We summoned Miss Leavitt expecting a straightforward contempt proceeding. Instead, she's presented us with a sophisticated First Amendment defense that directly cites our own precedents. We need to consider our response carefully." Several justices reportedly expressed admiration for Leavitt's legal acumen, regardless of their views on her original comments. Justice Kagan supposedly remarked, "Whatever we decide, I think we've all gained a healthy respect for her constitutional understanding." As the justices deliberated, law schools across the country scrambled to incorporate the hearing into their curriculum. Harvard Law announced a special symposium, Executive Speech and Judicial Criticism, Constitutional Boundaries after Leavitt. Stanford Law scheduled a panel discussion featuring former Supreme Court clerks analyzing the constitutional questions raised. Legal scholars began publishing emergency analyses in online law reviews. Yale Law Journal's forum featured a piece titled, "Contempt, Power and Criticism, The Court's Dilemma After Leavitt's Defense." The article outlined the difficult position the court now faced, either retreating from its contempt threat and appearing to concede Leavitt's constitutional arguments or pursuing contempt despite the formidable First Amendment defense she had constructed. Social media exploded with reactions from ordinary Americans. The hashtag #LegalGenius trended nationally along with hashtag Supreme Showdown. Young women across the political spectrum expressed particular admiration for Leavitt's poise under pressure, with TikTok videos analyzing her presentation style garnering millions of views. 48 hours later, as promised, the Supreme Court issued its decision. In an unusual 9-0 determination, the court announced it would not pursue contempt proceedings against Leavitt. The brief statement acknowledged the important First Amendment considerations raised during the hearing and reaffirmed the constitutional protection of robust debate regarding judicial decisions. Justice Barrett issued a concurring statement that legal scholars would analyze for years to come. While this court maintains its authority to protect the integrity of judicial proceedings, we must also respect the constitutional boundaries on that authority. Ms. Leavitt's presentation reminded us that our own precedents have consistently protected critical commentary on judicial decisions, even when that criticism is harsh or pointed. A democracy that cannot tolerate criticism of its courts is no democracy at all. The decision represented not just a personal vindication for Leavitt but a significant constitutional affirmation of the right to criticize judicial decisions. Legal historians would later mark it as a defining moment in the relationship between the executive and judicial branches. At her first press briefing following the court's decision, Leavitt maintained her characteristic composure. When asked about her remarkable legal defense, she simply stated, "I believe deeply in both the First Amendment and the importance of the Supreme Court as an institution. I'm grateful the justices engaged so thoughtfully with the constitutional questions at hand. The long-term implications extended far beyond the immediate controversy." Law schools reported a surge in applications, particularly from women and young professionals inspired by Leavitt's example. Constitutional law professors noted increasing student interest in First Amendment jurisprudence and separation of powers. Perhaps most significantly, the relationship between press secretaries and the court evolved. Future administrations became more careful and precise in their criticisms of court decisions, focusing on legal reasoning rather than questioning judicial motives. Simultaneously, the court became more restrained in its responses to executive criticism, recognizing the constitutional boundaries Leavitt had so effectively highlighted. 6 months later, Justice Barrett invited Leavitt to speak at Notre Dame Law School about executive-judicial relations. The event, which sold out within minutes, symbolized the remarkable transformation from adversaries in a contempt proceeding to mutual participants in constitutional dialogue. In her introduction, Barrett acknowledged the extraordinary circumstances of their first substantive interaction. Ms. Leavitt reminded us all that robust debate about judicial decisions strengthens rather than weakens our constitutional system. Her legal acumen surprised many, but it shouldn't have. In America, legal brilliance can emerge from unexpected places, and constitutional understanding isn't limited to judges and professors. As Leavitt took the podium to thunderous applause, the journey from potential contempt defendant to respected constitutional voice was complete. What had begun as an attempt to silence criticism had instead amplified it and established new precedent for protected political speech. The press secretary had indeed proven herself a legal genius, not through academic credentials or judicial appointment but through the powerful application of constitutional principles when it mattered most. If you found this breakdown of this historic constitutional confrontation enlightening, please take a moment to like and subscribe to our channel for more in-depth political and legal analysis. Comment below with your thoughts on the balance between judicial authority and free speech, and don't forget to hit the notification bell so you never miss our latest content.